In this video, I'm going to share with you some of the things that I took away from the alternate jurors' comments after the Derek Chauvin trial that I think can help lawyers be better lawyers and consumers be better consumers of legal services. So without further ado, let me dive into some of my takeaways from the Derek Chauvin alternate interview. Now, there's a lot of commentary and a lot of people who are perhaps more qualified because they were licensed attorneys in that state to speak about the actual legal analysis under the applicable law. The charges that Derek Chauvin had are not charges that we have in Florida. Yes, we have murder charges, yes, we have manslaughter charges, but each state can have very different definitions for each of those offenses. But each state can define those charges differently. They can have different degrees, and of course, they have a different sentencing structure. For example, in Florida, your first-degree murder is a life sentence, whereas in other states, it may not necessarily be a life sentence. And that's what I want to do today, and I want to talk more about the takeaway as a trial lawyer watching that trial. And then also I want to talk with you about, as a consumer of legal services, what that trial can teach you if you have to select an attorney. Obviously, this was a very emotionally charged trial, an emotionally charged case, and there's probably a handful of attorneys in the town that would have even agreed to take a case like that. So as a consumer, that's your first important takeaway. If you're charged with a horrific crime that's drawn a lot of media attention, or it's a high-profile case, you need a lawyer that's experienced in handling high-profile, high-stakes litigation. I don't know Derek Chauvin's attorney personally. I don't know him by reputation, but I'm sure that he was one of the few attorneys in town who agreed to take that case. Whatever his motivations are, I can't impugn those. All I can say is when you're selecting an attorney and you have a high-profile case, you want to make sure that attorney is no stranger to the pressure and no stranger to the lure of publicity. And I'm sure that in this case, there was extensive work done to minimize anything that could have been leaked from the private life into the public. But again, when it's you and you're the one that's facing the prosecution, you definitely want to work with your lawyer to make sure you understand and have control over the image you're projecting to the public 24 hours a day, 7 days a week. Obviously, the Derek Chauvin trial was a jury trial, and we could talk for literally days about the nuances of a jury trial, selecting a jury, the decision to have a jury trial. Sometimes that's not a foregone conclusion. A lot of things like that. What's come out so far post-trial has been an interview with one of the alternate jurors. Now, when you select a jury, whether it's a 6-person jury or a 12-person jury, and most of your juries in Florida are going to be for 6 people, you're going to select 1 or 2 alternate jurors. They're not going to know they're the alternate, but the reality is, whether your trial lasts 2 days, 2 weeks, or 2 months, there's a chance that somewhere along the line you'll lose a juror. Someone's kid will become sick, someone will be hospitalized, there'll be some unexpected emergency, or worst case scenario, one of the jurors becomes tainted somehow. They see a news clipping, they realize they know a witness or a participant in the trial, something comes up that makes them not a neutral juror. And at that point, the attorneys are going to motion to have that juror removed and have the alternate impaneled as that juror. And what will typically happen is the trial will then proceed as long as there's at least 6 or 12 people in the jury box that can deliberate. And then once you make it through closing arguments and the jury's been instructed on the law, the judge will send back the deliberating members of the jury to the jury room to begin their discussions. And he'll keep behind the alternate jurors. And he'll tell them that they've been selected as alternates, that we couldn't have done our job without them because they could have had to step in at any time and deliberate. But now that the jury's begun their deliberation, their job has come to an end, and with everyone's thanks, they'll be excused. Now, most criminal trial attorneys are going to make a beeline for those alternate jurors. I mean, it's like a dog after its prey. Boom, you're going right after those alternate jurors. Because those are people who watched your performance, evaluated your evidence. They were a hair away from being on the jury deciding your client's fate. And so if you want to assess your performance, if you want to know how the jury might go, it can be helpful to talk to the alternate. Of course, you got to bear in mind that's one person. They could have been the lone vote for guilty, the lone vote for not guilty. Who knows? But there was a reason you were fine with them being an alternate. You thought they'd be a good potential juror. And all those characteristics stay with them even though they weren't selected ultimately to be one of the jurors that sat in deliberation. So you're going to want to talk with them, pump them for information, find out what they would have voted, and try to get tips or feedback from them for your own performance. Now, sometimes the judge will instruct you not to talk to the alternate or to tell the alternate they don't have to talk to you. But frequently I'll send one of my members of my team out to the parking lot to just happen to bump into the alternate as they're leaving. Something my dad does for me. I'll send my dad out to try to talk to the alternate to get a feeling for how the alternate would have voted and any feedback they have from me as far as improving my performance in trial. The alternate in the Chauvin trial has come out and talked about some of the pivotal moments in the trial for them. One of the first things they talked about was the ineffectiveness of the defense in several ways. One, they said the defense overpromised and underdelivered, and I'll talk about the dangers of that in a second. The other thing that they talked about was how uncomfortable they felt eye contact was with the defendant, how he made them feel uncomfortable by looking at them or locking eyes with them. The alternate also focused on the strength of the prosecution's presentation, but above all, the thing that struck me as a trial lawyer the most was that they focused on the dynamics in the courtroom of the defendant and his interaction with other people. As far as I could tell from reading her comments, she commented that he made eye contact a few times and made her feel very uncomfortable, and this played negatively into her perception of him. She formed the opinion that he was a leader, that he had taken a kind of a leading role in the incident, and that he felt he was above criticism, above correction, and had kind of brushed off other people as if he knew what he was doing. And I think she was suggesting that a lot of that was not only informed by the evidence, but by what she could observe about the man's demeanor, his presentation, things like that. And I think that's very important because when you're in trial, like it or not, you're being assessed on the tangible and the intangible aspects. Unfortunately, the way you look makes a difference. Attractive people are going to have a better chance of being acquitted. Sounds unfair, but it certainly is. People who are pleasant looking, who seem open, smiling when appropriate, or at least giving the appropriate demeanor for the situation, that are likable, are just that. They're likable people, and that likability stays with them throughout the trial. You can't tell a person to stop being likable. The judge can't do anything about it. A person who's charming, charismatic, all of those things, that will come through to the jury and that will help you. Unfortunately, the inverse is also true. People who are creepy, who are scary, who are intimidating, all that comes with them to the trial as well. If you're a hulking, scary looking person with a shaved head and facial tattoos and scowling, you're going to project a certain image to the jury, like it or not. And some of those impressions can be negative. We talk with our clients about their courtroom presentation. We tell them to dress conservatively but appropriately. We tell them to keep kind of a neutral expression, to pay attention, not to focus too much on any one juror, and really to avoid making anyone uncomfortable in the courtroom. So staring down a juror, completely inappropriate. Gently kind of passing your gaze over, monitoring, if there's a sound, looking, that's fine. But you don't want to make the jury feel any more uncomfortable than they already are. No juror is ever going to tell you, oh yeah, I convicted your client because he scared me. But subconsciously, that's the reality of it. Humans are going to react to threats. If someone challenges us, makes us feel frightened, our reaction is going to be to put that person away from us. One of the things we talk about in law is being kind of true to the moment, of not acting, of not faking. But I think it's important to understand that there is still a role for playing a character. And that character you're going to play is the most polished version of yourself. It's the most aware version of yourself. And so what I tell my clients to do is I don't want you to act. I don't want you to be fake, but I want you to be on your best behavior. I want you to be the way you would want to be on a first date or meeting your in-laws for the first time or for your grandmother. You want to be that best version of yourself. And that's the version that I want to see you come into court with. Another thing I took away from reading the alternate's comments was that she felt the defense had overpromised and in essence underdelivered. Now, the letter of the law tells you the defense never has to prove anything. The defense can sit there, put their feet up, lay back, go to sleep, and if the evidence isn't there, you got to find the client not guilty. And when I pick juries, I talk to them about that concept. I say, hey, I could leave, come back 2 days later, if the state hasn't proved their case, you got to find my client not guilty. And jurors will agree with that. But that's not the reality of it. The truth of the matter is a trial is a battle of realities. You have your version of reality, they have their version of reality. And you have to convince the jury that Their version of reality doesn't matter. And as a defense attorney, you're trying to propose alternate realities, things that are plausible but opposite of or contrary to what the state's saying. So it's a battle of realities. Still, even though you don't have to technically prove anything, you do need to give the jury some snapshot of that reality that you're arguing. And it's a very fine line, because if you take on an obligation and don't fulfill it, you've lost credibility with the jury. If you tell the jury, I'm going to show you something, I'm going to prove something, I'm going to demonstrate something, and you don't back that up, then you have failed to live up to that promise. You've probably made yourself less credible, and you probably harmed your case. And you didn't have to take that on. You didn't have to tell the jury that you would do anything. That's an extra step you agreed to take. So if you're going to take that step, you better be sure that you can back it up and bring it. And here, for whatever reason, this alternate thought the defense attorney had made promises they didn't deliver on. And it may happen. Sometimes you may change strategies. Sometimes a case may go so well or in an unexpected direction, and you no longer want to present the evidence that you talked about in opening. If that's the case, then I think you should explain to the jury and acknowledge it. You should say, yes, I told you I would do this and this and this. I didn't need to because the state didn't do this, this, and this. One of the most common things that I do in jury selection is I tell in opening what the evidence is going to be. And I'll even tell the jury, this is what my client will say. And I'm allowed to do that for a couple of reasons. One, what a lawyer says in opening isn't evidence. So you can say whatever you think is reasonably likely to happen. And although the jury may hold it against me, the law doesn't allow the state to say, well, Mr. Delgado said he was going to do this, this, and this, and didn't, because that would be commenting on the client's right to remain silent and to be shifting the burden of proof. So I can say all the things my client's going to say and do, and then not do them at all, without really any risk from the state pointing out that I didn't do those things. And as long as I explain to the jury why I didn't have to do them, I can get away with it. And more importantly, what I can do is I can give the jury information that they will forget came from me and believe was part of the case. I can say, my client will tell you this and this and this. I ultimately don't put him on, he doesn't say it, but the jury is still remembering that comment. And unless you have an outstanding prosecutor who knows how to deal with a trick like that, to say, remember what Mr. Delgado said isn't evidence, which will probably only drive home the things I said, then they're going to say, well, I know that whatever I said happened, and what about that? That will somehow work its way into the trial as evidence. It's a great underhanded tactic to control the narrative. It's a great way of setting your reality up without facing the blowback that this attorney got from the alternate, which was overpromised and underdelivered. In a situation like that, had he just said, I didn't have to do it because they didn't do their job, I think that would have been a satisfactory explanation to most jurors. So the takeaway here is, if you take up a burden, be sure you can meet it. If you can't, explain to the jury why you cannot. Don't be frightened of taking on that burden, because it's a very important reality that simply arguing they haven't met their burden, simply saying they don't have enough evidence, is really not going to be sufficient in most cases. The jurors want an explanation in the form of a story. They don't want to hear how the state's evidence doesn't measure up. They want to hear a story that says why your client is innocent, or why the state's evidence is faulty, or why the state's reality is not the only reality that can be beyond a reasonable doubt. So if you're going to take on that burden, be mindful of that. There you have it, a handful of observations gleaned from a few sentences from the alternate. I mean, that's the thing about a high-profile trial like this. You can spend hours dissecting every part of it and coming away with some sort of insight about each part. This is a trial that's going to be analyzed for a long time. It was a landmark trial culturally, and probably marks a sea shift in our legal culture. There are going to be people who see this as a long overdue result. There are going to be some people who see this as the end of an era. There are going to be some people who feel that this case reached the wrong result, that police officers should be afforded some special standard. There's going to be people on all sides of this case. And watching it as a trial lawyer, when I watched this case, I watched it as a citizen, and I had my own personal reaction to it as a citizen. But when I watched it as a trial lawyer, I analyzed it for what I could take away to improve my personal practice. And just from that alternate's few sentences, I picked up on several key things that I had kind of known of and thought about, but I hadn't heard come out of a juror's mouth at all. And those were the things that I wanted to share with you. The importance of not taking on a burden that you can't meet, of not overpromising and underdelivering, the importance of managing your reputation and your image from the very beginning of the case through the very end, not just from when you wake up, but from the moment you're charged through the end of the trial, making sure you're presenting an image that you're aware of and conscious of, and controlling the things you can control. So as a trial lawyer, I could take away a lot from this trial. As a citizen, I took away a lot from this trial. As a country, I think we took a lot away from this trial. Regardless of where you ended up on this trial, regardless of what your personal beliefs were about the verdict being the right one or the wrong one, there's a lot that we can learn from this trial. And I hope you found it as interesting as I did. So I want to thank you for spending this time with me. If you found this content useful or entertaining, please click on the like button and subscribe to our channel for more videos like this. Thank you.